Article 18 prescribes that the data subject have right to ask an organization to limit or restrict the way they process their personal data under certain circumstances. As per Article 18(1), the data subject shall have the right to restrict the processing in following four cases. First case, data subject can request to limit or restrict the processing when data subject believe that the data is incorrect and they are waiting for the organization to confirm its accuracy. Second reason, if the company is processing the data unlawfully and data subject want them to stop using it temporarily while the issue is being resolved. Third point, data subject can request to limit or restrict the processing when the company does not need the data anymore for their purposes, but then data subject need it for legal reason. For example, data subject is closing one of the financial application as he no longer needs that, but he needs some financial record for tax purposes. Data subject can ask them to restrict their processing but to keep the data accessible for legal reason. Fourth point, if data subject have objected to how their data is being processed, but data controller is still checking if the reasons for processing override the objections by the data subject. So, only under these four circumstances, data subject can ask the controller to stop the processing of their data. Let us now discuss Article 18(2). As per Article 18(2), when data is restricted, the controller can only do certain things with it. Let us discuss what are the things. First one, controller can still store it, but they can only process it further if it is agreed by the data subject. Second point, controller can process it to establish, exercise or defend the legal claims. Controller can also use it to protect someone else's rights or for important public interest. Let us understand this with an example. If the data subject's data is essential to protect the rights of the another user in a harassment case, the controller can process the data to ensure the rights of that other user is protected. So, these are the requirements of Article 18(2). Let us now discuss Article 18(3). As per Article 18(3), if the processing restriction is going to be lifted, the controller should inform the data subject before they start processing the data again. Let us now discuss some of the key aspects with respect to Article 18. Right to restriction can be invoked by the data subject only in following four situations. First one, when accuracy of personal data is contested. Second, when the processing is unlawful and data should be erased under Article 17, but the data subject opposes the erasure and wants to limit the processing. When the purpose of processing has been achieved, but the data subject do not want to delete the data, since the data are needed for some legal claims. When the data subject has objected to the processing under Article 21 of the GDPR and requests restriction while assessment is carried out. So these are the four reasons under which right to a restriction can be invoked. Please note In such case, the controller is only allowed to passively store the personal data but can no longer share, disclose, erase or perform any other type of processing operation on this data unless any of the specific exceptions under paragraph 2 applies. Let us now discuss some of the important provisions of Article 18 by way of multiple choice questions. Which of the following is one of the valid ground for a data subject to demand restriction of processing their personal data? Correct answer is option C, that is when processing is unlawful. This is as per Article 18.1. Article 18.1 prescribes 4 situations under which data subject can demand restriction of processing their personal data. Unlawful processing is one of them. Let us now discuss next question. Which of the following is not a valid ground for a data subject to demand restriction of processing their personal data? Correct answer is option A, when data subject files for the bankruptcy. Please understand, Article 18.1 contains option B, C and D. So these are the 3 reasons wherein data subject can demand restriction of processing their personal data. However, option A is not covered. Article 18.1 prescribes 4 situations under which a data subject can demand restriction of processing their personal data. That's all for this lecture. Thanks for watching.